Vice Chair Chavez,
Present.
and Chair Palmisano.
Present.
We have 9 present.
Thank you. Let the record reflect that we have a quorum. Next, I'll recognize Commission Chair Ginder to convene the Charter Commission.
Thank you. My name is Peter Ginder. I'm Chair of the Minneapolis Charter Commission. I'll call together this meeting of the Charter Commission, which is a joint meeting with the Minneapolis City Council's Committee of the Whole. It asks the clerk to call the roll to verify the presence of a quorum.
Oh, there we go. Commissioner Boone,
Present.
Clegg, Davis Carter is absent. DeMillo,
Present.
Doherty,
Present.
Garcia,
Present.
Hawkins is absent. Hill,
Present.
Kozak, Metke,
Present.
Perry, Sandberg is absent. Smith, Vice Chair Rubenstein,
Present.
and Chair Ginder. We have 12 present.
So moved. Garcia.
Second? All in favor of the motion, please say aye.
Aye.
Any opposed? That President, and recognize that you will be the presiding officer for this meeting.
Thank you. Mayor Fry, council members, and commissioners, we're here to receive a report from our professional staff about continued work to implement the new governance system. That amendment to the city charter was authored by the Charter Commission and was approved by our voters in the 2021 municipal general election. Over the course of the past 22 months, the city has been working, I'll say hard, to implement that form of government. We knew additional work would be necessary to address gaps between the voters' approval of an executive mayor and legislative council system and the framing of the city's professional administration and how those pieces work together. The purpose of this joint meeting is to get a briefing on further charter amendments that support the implementation of this new government system and structure. Before I call on our city attorneys to brief us on the scope of those proposed charter amendments, I want to recognize Mayor Fry for a brief summary of the work that the city has already done to this account.
Thank you, Madam Vice President and Chair Ginder, members of the Charter Commission and City Council members. It's an honor to be here with you. I will be brief as most of the information that I'm going to provide you're already well aware of. In November of 2021, the voters passed a change to our charter that shifted our form of government to a clear executive in the mayor and a clear legislative body in the council. And as I've said many times before, the work of implementing this new structure was largely carried out by staff. And so I want to give a huge thank you to all of the incredible staff members that have stepped up in an incredible fashion to help carry out the voters' wishes. The good news is that in incorporating this new government structure, Minneapolis is not alone. The strong majority of the largest cities in the country have a clear executive mayor and a clear legislative body in the council. The federal government has the same form of government. All 50 states have that form of government. It gives you clear delineation as to who has authority over what. And so it is not new necessarily to us. We were able to take a whole lot of feedback from a number of different entities around the country. And within just 3 weeks after the election results were declared, my team organized a task force to study this new structure. And I charged the task force with thinking broadly and in the city's long-term best interest and to give their best informed recommendations as to how this new government structure would be set up. The vast majority of it, as far as the delineation of roles, had already been established between the executive and the legislative body, but the question as to how to set up the administration itself was still largely in the air. And so as I told the work group at the time, the city needs to clarity on the roles and responsibilities of the mayor and council, to clarity on accountability for results, and clarity around how the city's elected leaders as a governing body communicate with each other and with the community and with their constituents. The work group submitted its report with recommendations in March of last year, and after reviewing those recommendations, I submitted to council in that same month my proposal to organize the executive branch with a cabinet structure that has three executive officers reporting directly to the mayor in the Commissioner of Community Safety, a Chief Operating Officer, and a city attorney. So with the charter amendment, we have the overall governance framework in place, and with the ordinance, we have the internal operating structure in place. But as the council vice president stated, we've known all along that we do need to still address some gaps that exist between the charter and the ordinance itself. So our attorneys have been working really tirelessly this year to identify those gaps and to draft language that might address those issues. There are so many people to thank in terms of setting up that work, but three of the foremost are actually right in front of me, in Susan Trammell, and Kristen Anderson, and Casey Carl. I thank them for a whole lot of work to get this set up. All of our work to date has been done in full view of the community, not just through the council's public meetings and hearings and its regular legislative process, but also through our websites, where all our reports, actions, and work products have been posted, along with timelines and details how that work is ultimately progressing. A lot of work has taken place. There are still a few gaps left. We're hoping we can come to a resolution to have that structure of government work not just for today, but for many generations into the future. I think that's an exciting endeavor for all of us to take on collectively. So I'm excited to see the staff's recommendations and to continue this important work together. Thank you so much, and I'll turn it back to you, Council Vice President.
Thank you, Mr. Mayor. At this time, I'll ask our staff to present their recommendations, and I'll also ask you help us review the documentation that we have and how you intend to cover all of this information for us. Just to maximize our time and be as efficient as possible, I'm going to ask everyone to hold questions to the end of each section. I'll ask staff if you would please pause at the end of each section so that we can see if there are questions at that point before we go to the next one. So I'll recognize our city attorney, Kristen Anderson, to go ahead and start us off.
Thank you, Council Vice President, members of the commission, members of the council, Mr. Mayor. We at the city attorney's office, in conjunction with Clerk Carl, have worked very, very hard on the package of proposals that we've put forward to you today. We have touched not all, but many of the articles of the charter to do a few things. As the mayor has pointed out, and Chair Palmisano had pointed out, the biggest chunk of the changes that we've made are really to conform. Then we don't have to rely on special laws that exist at the state level, some of which date back to the 1970s even. So with those brief remarks, I want to turn it over to Susan Trammell, who has done the lion's share of the drafting work on the package before you. So go ahead, Susan.
Thank you. Chair Palmisano, Mr. Mayor, members of the Charter Commission, members of the City Council. If you could have the first slide, second slide. We've somewhat touched on this, but I want to tell you what's in the packet before you and then what we've done. For each article that has been amended, you have a redlined draft showing changes. That is true for every article that we have touched, and we will walk through them one by one. And then there's also a copy of this PowerPoint that's in your packet as well. So in general, we made some corrections through, if we touched an article, we made corrections where needed There's a lot of inconsistency between capitalization. We're trying to get that straight. We think we've arrived at a place where we're going to be consistent going forward with these changes. There's abbreviations that sometimes are used and other times are not. And there's the gender neutral language that we are inserting wherever we encounter gender language used. We also made amendments to further implement the executive legislative structure. We have that new structure, as Mr. Mayor and the city attorney have mentioned, codified in our ordinances for internal operating structure. But because of that structure, we still need some changes to the charter. And if we pass these changes, the charter and the ordinances will be totally aligned. We also have made some amendments to our charter because as a charter city, our charter can control, and there are many instances where we don't have to then go to the legislature to seek special legislation. And some of the amendments that I will talk about later today deal with that situation that will prevent us from having to go to the legislature to seek that special legislation going forward. Next slide, please. So in Article 1, there are just a few changes. The first change is a very minor clarification. In section 1.3 authority, we added the 2015. That's when our charter was plain language restated. And this section causes a lot of confusion, and we believe that adding the 2015 clarifies that we're talking about what that 2015 restatement actually did. That's the sole purpose of that. In the next page, on page 2, under Part C, this is where I talked before about amendments to eliminate the necessity of seeking legislative approval. And if we add that in a later article, then we would want this A added, which says that we are now in this area that we are saying our charter controls, we're going to supersede all of those civil service special laws that we had sought over the many years. And that's what that language does. The other change to Article 1 is an all powers clause edited in section 1.4 to make it very clear that we have all the possible powers that are granted to home rule charter cities. And those are the only changes for Article 1. I can answer any questions you may have.
Thank you. I'm going to remind my colleagues to please pull the mic up to you instead of touching the microphone head. Maybe if there are multiple questions, you could just use this like we do on the dais. Questions or comments about this first section at this point in time? I'm not seeing any.
Next slide, please. The next article that we have edited is Article 4, City Council section of the charter. And we start off in 4.1a, just moving the word authority to after oversight, because that's before read as an add-on, and by adding it at the end, it's very clear that legislative policymaking and oversight are all the authorities of the City Council. The next change in this article has to do with vacancies, clarifying the various different situations when a vacancy occurs that a council member has left. That an early vacancy is one that occurs before March 1st, and that when the special election is held, that person then elected at the special election is then qualified, they take office and serve the remainder of the term. Then we clarify the late vacancy, that the council appoints for a late vacancy that's on or after March 1st in the year of an election. Then the council would appoint someone to serve the remainder of the term. The third change clarifies what happens when there's a vacancy after the opening of the filing period, and this would be a change from what is in the charter currently. And it would indicate that the vacancy that occurs in that time period, the position would remain open and for the remainder of that unexpired term. Okay. The next change on the next page has to do with removal of both the mayor or a council member. This is in situations under state law in which serious malfeasance or nonfeasance is present, and it sets forth the due process for that and codifies in the charter how that would happen. And that would be the council was the authority to make that removal. There are edits, that was an addition, and so there then is renumbering of the rest of the article, and we make the next changes under the city clerk section. And clarifying that the clerk is an officer of the city, some consistency, always using city clerk and capitalizing it, correcting the school district to its proper name in that section, and those are just those types of edits for the clerk's section. The next edited section is in the city auditor. The auditor language for removal was edited to also have some due process added to that should the council make determination to remove the auditor. And then I added language to staff regarding appointment and supervision and discipline of any of the city auditor's staff. Those, I believe, are the, there's only a couple more which are technical corrections and adding the after notice and hearing about the removal of the mayor or a council member. One of the problems, if you look on page 9, it said remove an elected officer, and that conflicted with other sections because there's the park board and the BET have their own sections, and so there were conflicts. So this eliminates the conflict and narrows it to just the mayor and the council member. That ends the edits to Article 4, and I can stand for questions on that.
Thank you. I see Council President Jenkins and then Commissioner Kozak. Thank you.
Thank you, Madam Chair. I am curious if on Article 4, bullet point 2, the council appoints, does it stipulate a application process, or does the council?
Council Chair Palmisano, Council President Jenkins, if I understand your question correctly, you're asking whether or not when we drafted the vacancy provisions and the appointment of a council member to fill a vacancy, whether there's a process included in these charter provisions, and the answer is no. The thought process in moving forward with the charter changes is to leave the technical details of the how to either the council rules or ordinances to keep this at a higher level and keep it simpler and more usable then in the long run.
Follow up then, do we have council rules that cover this provision?
Chair Palmisano, Chair Ginder, members of the council and the Charter Commission, and Vice President Jenkins, as of today, we do not, but there are rules that are being drafted, and those provisions can be included going forward.
Just a correction, President Jenkins, but.
I'm sorry.
Yeah, thank you.
Commissioner Kozak, followed by Councilmember Ellison.
Thank you. Madam Chair, the question I have is on the removal of council members and/or the mayor. What is current law? What governs removal of council members or the mayor in midterm?
Chair Palmisano, Chair Ginder, members of the council and the Charter Commission, and Commissioner Kozak. There currently is nothing in our charter specifically, but when the question has arisen, there is statute that provides, and that's what the section is based on as drafted, statutory section from the Minnesota statutes that it's patterned after. It has quite a high burden for removal.
A high burden, but what is the burden? Or who ultimately decides under current law?
I'm sorry, I need to correct myself here. There was a clause in the charter, and it says the electing or appointing body, or in the case of an elected office, the city council, acting by 2/3 of its membership, may remove any officer for cause after notice and hearing. And so the language that's new is the malfeasance and nonfeasance, and let me see what else I added. Or conviction of during the term of office of a serious crime. And so the malfeasance or nonfeasance relates to the performance of the duties of the office. And the way that's worded in the removal section on page 51, if you have your charter book with you, which is in the city council section again, or is that in 8? It's in Article 8 currently. That has some issues because it refers to any elected office, and yet there's provisions in both the park board and in the BET that conflict with that. So it's kind of all over the place, but the basis for the legal reasons for removing someone are now as written based in state law, the same standard.
Okay. So in effect, this really doesn't materially change the process.
I would say that that is accurate, that we're not trying to change it, but we're trying to add some clarity to it.
Okay. Very good. Thank you.
Thank you, Chair Palmisano. Just to give a little bit more detail about this, again, the process hasn't changed. What exists in the charter right now is simply for cause with absolutely no direction about what cause might mean. And so what we try to do in the additions in this proposal is to, again, borrow concepts from state statute, serious malfeasance, nonfeasance, conviction of a serious crime. All of those things are either defined in state statute or have lots and lots of case law explicating them under state law. So we're trying to borrow some concepts so we're not just making things up. It always helps when we have definitions. And then in terms of process, again, process hasn't changed, but I think that you had asked a question about, so who's the ultimate determiner? It's 2/3 vote of the city council, but this is due process. So it's a quasi-judicial decision that would be appealable to the Court of Appeals if there was a dispute about whether the incumbent felt that they were inappropriately removed.
Thank you, Madam Vice President. Also just had some questions about removal. I know we can't sort of relax the state standard, but we could raise the state standard for a removal process. Is that correct? Increase the burden? you could maybe use mine.
I'll grab Susan's. Councilmember Ellison, and maybe you can clarify your question a little bit. So again, what we have right now is simply cause without any sort of explication of what that means. So
Right, but we're sort of, you know, creature of the state and all that. We're governed by state statute, meaning like, and the way that I, you know, as a layperson, the way that my brain sort of lands is that we couldn't necessarily relax the cause for removal, but we could, for example, you know, say that it has to be only we could, you know, delete malfeasance and nonfeasance. I'm not proposing that. I'm just saying, for example, and have it be that the standard is committing of a serious crime, right? Or we could not increase the standard. You know, I guess that's the question. I feel like there are other state laws that sort of apply where we can increase the standard, but we can't relax the standard.
so make it more difficult to remove
Sure,
an
yeah.
official. I think that, I mean, we would have some flexibility to define what cause means under our charter.
Okay. I asked just because, you know, given that we hadn't quite had it spelled out in this way, you know, my brain instantly goes to like worst case scenario, the Tennessee lawmakers that were removed in a way that I think a lot of people would feel like was maybe unjust or whatever. Not that this council would do that, but, you know, want to make sure that we're not writing something in a way that, you know, could land us in a situation like that, you know, or, you know, undercut the will of the voters for something that maybe is offensive to the body, but not necessarily, you know, a crime or whatever. So, yeah.
Yeah, I appreciate that, and I will also say the reason why we chose, you know, to define cause as defined in state statute, again, is because there are definitions of those terms in state law, so it's not just whatever the body decides, and I think that the very important piece of being able to have an appellate review through the judicial process also is a safeguard against the kind of thing that you've described.
Commissioner DeMello.
Sorry, member, to restate the question, Member DeMello asked if the successor who is appointed when there's, in section 4.2D, a late vacancy, who is appointed to serve out the remainder of the unexpired term, if that person could then run as the incumbent. My answer to that question would be yes, because they are appointed and they're serving as a council member.
Any other questions or comments from my colleagues? Councilmember Ellison, are you still in? Okay. All right, next section.
Next slide, please. The next article that we have proposed amendments to is Article 7, the administration. You'll see on the first page there's just one gender-neutral change, and on the second page there are a number of changes, changing gender-neutral to indicate the position instead of the his or her. And at the very end of that page, we make the first edit. We used the word appropriate instead of that the mayor needs. When we're talking about the resources of the office, that's consistent with the way the language is used in both the city clerk and the city auditor sections about appropriate resources. So that's why that change was made. Then we simplify on page 3 to not list the various positions. Oftentimes the titles that the staff uses aren't matching with the names in charter or when we have ordinances. And so we removed those and just indicated that the mayor shall appoint such staff as necessary to run the office, and that's what that change is. Then the big changes come on page 4 regarding the executive offices. Now, on page 4, you note that where it used to say in the charter departments, we've now added a new section, executive offices, and there will be another section that deals with the administration, which has to do with the other departments. And these following executive offices that are listed on pages 4 and 5 are the ones that were included in the ordinance that was adopted by council last year. So this establishes then in the charter those executive officer positions that were in that government structure organization plan presented by the mayor and adopted by the council by ordinance last year. So the first one is the Office of Public Service, the second is the Office of Community Safety, and the third one is the Office of City Attorney, which is currently in the charter. So all three of them start out they have the same structure for their sections. They're under the supervision of that executive officer, that they are under the mayor's oversight, which is part of the government structure with executive, mayor, and legislative council, and that they're responsible for those administrative departments as designated by the mayor. And that they then, under this way we have proposed this draft, the city operations officer would be responsible for appointing the heads of the departments under their authority. The Office of Community Safety, this Community Safety Commissioner would be responsible for appointing the heads of the departments that are under the Community Safety Commissioner's authority, with the exception of the police department and the fire department, which they are spelled out specifically in the next section as being appointed, nominated and appointed with consent of council. And the three executive officers would also all be appointed, nominated by the mayor and appointed with the consent of council. And that's included here in Part B, that the mayor nominates and the city council consents, and that's similar to what we have now. The Office of the City Attorney is similar to that which was in the charter before. It has some additional details to clarify, and it again indicates that it does not apply to the Minneapolis Park and Recreation Board. Then we move into section 7.3, in which indicates that the council by ordinance must establish and organize and otherwise provide for the city's administration. That word is different. Before it said the departments, and so now it says the administration. And it spells out that it shall include the police department that's funded as required by charter, and the fire department, which is funded as required by charter. But those sections have moved from the prior Article 7 to Article 9 of Finance, and we can, I will point that out when we get to Article 9. The other things that are, you'll see that there's a lot of strikeout that comes up, and those things relate to the commissions. First, the Civil Rights Commission, and then the Planning Commission. And those have been moved to a new Article 10. So I'll point that out later too. They've been, the Civil Rights Commission almost transferred word for word, and the Planning Commission as well. I provided the red line as if we had an Article 10, so when we get there you can see how they changed. And then there are edits to streamline the provisions of both the police department and the fire department. And so there are strikeouts there as well. And then, like I said, the funding provisions have been stricken because they're being moved to both have been moved to the provision for the finance in the charter. And those are the changes to Article 7.
Thank you. Are there questions from my colleagues? Councilmember Payne.
Thank you, Vice President Palmisano, although I don't think this is on still. There we go. Thank you, Vice President Palmisano. My question is around the removal of our charter departments. Obviously, we've consolidated a lot of the reporting structure underneath the executive offices, but I think this is a giant loss for accountability, and I feel like the intent of the new government structure was to clarify council's role as an accountability body, and we're losing a lot of that oversight of what the administration is doing by way of their department heads. And so I think while I recognize the value of removing some of these operational details out of the charter, we need to strike a better balance when it comes to oversight. So not just limiting council appointment to just the executive offices, but I think we should be thinking about the deputies underneath, and I would suggest that the police chief and the fire chief and the director of emergency management and the director of 911 kind of operate as deputies within the Office of Community Safety, and then we have our 3 deputies that we've specified in the Office of Public Service. But I think that just a complete strike through of all of that is missing the mark from my perspective.
Other thoughts or questions from my colleagues? Member Doherty.
So in looking at the information that was provided to us prior to this meeting, I was looking at the difference between the strong mayor provision in St. Paul and what is being proposed here. And exactly what Councilmember Payne was talking about, it seems to me the strong mayor in St. Paul still relies on the council in terms of either suggesting the people who are nominated and then the mayor picks them, or that the mayor nominates and then the council approves. Whereas this has changed from the appointment clause, where the council had a part of appointing what was called the charter department heads, to that really being removed to just these 3 individuals. Is that correct? 5.
Others? I'm not seeing any.
The next article is Article 8, and we changed the definition section to be limited to just officers defined, adding in the executive and administrative officers, which are then dealt with in further detail in Article 8, and including the other officers that had been in the prior version, but reorging them a bit. The strikeout language is included below it. And then we then have officers generally, and have done some edits to that section as well. In subpart B, the bond section has been edited to align with state law, and it parrots Chapter 415 that has a section in it related to bonds. We took out tenure and vacancy and holding over, but those are dealt with later under the executive officers in the new section that's added. Same thing with resignation and removal and vacancies. The next section, 8.3 from the former charter, has also been edited. We have added in a section about commencement of office to make it clear what happens when someone is elected in either a regular general election or in a special election. I think it was even this year that people were sworn in on January 1st, which, is it next year? That's, or you will be, unless there's no way to get this done by then, so you will be. But this would change that so that it becomes a non-holiday, okay? And then in a special election, again, it's the first weekday that is a non-holiday after the election and the person being qualified. We put in here a determination of vacancy, and that was never spelled out in as much clarity as to how to determine when a vacancy is in an elected office. And that, again, it's limited to the mayor or council offices because the other boards determine their vacancies. The holding over from that section stayed, it's just further down there. And then we have this new section where it used to talk about other officers. It's specifically designed to deal with the executive officers. And the executive officer are those officers that were established by 7.2, the Commissioner of Public Safety, the City Operations Officer, and the City Attorney. And it spells out that the mayor nominates and council consents, and then there's the appointment. There's also an interim capacity provision when pending the appointment of a successor, that there's an opportunity to have this interim person serve for up to 180 days while it's going through the process. And after 180 days, council approval must be required. For the failure of appointment, we did change that because the 90 and 30 days that are currently in the charter have been proven to not be workable to get things handled that quickly when you're trying to appoint someone to one of these positions. We've added on page 7 a commencement of service section, that they take office upon appointment and pursuant to the charter, that they serve at the mayor's pleasure in the unclassified service, and that the term coincides with the mayor's term. And that if there's a vacancy in the mayor's term, that doesn't necessarily end the executive officer's term. We added a resignation section and a vacancy section. Also a section regarding the appointment of their deputies. For one or more deputies, then again, those would be in the unclassified service. For section 8.5, the administrative officers, those would be someone heading a department that's established by the charter or by ordinance, and does not include an executive officer, the city clerk, or the city auditor. Okay, and that it's indicated in the charter that the appointment of these persons would be as provided by the charter, the enabling ordinance, or the applicable general law. And in some cases, we have some general laws that apply. The next section is the civil service section, and the city's civil service has both the classified service and the unclassified service, and that provision's added at the get-go. And then we've slimmed down the civil service section and indicated what the policy is in more of a policy statement, and have proposed that you remove all of the details because the details can be included in the Civil Service Commission rules. And so those have been taken out. And then we define both classified service and unclassified service. The unclassified service definition is similar to that which is included in state law for the unclassified service. And this is where we have now put in provisions that allow us to not have to seek special legislation from the legislature whenever there's a need for an unclassified position. We, back in 2003, sought the authority from the state legislature through a special law to adopt an ordinance setting forth the process for determining various positions in the city. And at that time, there was indications that we would then go back to the legislature and get all of those special laws repealed, but that never happened. And so now we still have all those special laws apply and our ordinance process. And so by putting the process here in the charter, we can go forward without having to seek special legislation. And then that earlier provision that's in our charter, referring in Article 1 to the special laws, those would be superseded. So we would have everything we need here in Article 8 for the appointment of those positions. The other thing that was added is that whereas some of the special laws regarding various positions are different as to terms and conditions or rights in relationship to the classified service, this makes it the same for all the positions by adding sections F and G, the terms and conditions and the rights in relationship. Then we've added a last clause that indicates that the effects of the amendments are such that they don't impact anyone in a unclassified position or any positions that are created pursuant to current process prior to the effective date of any of these amendments, which we're using a January 1st, 2025 date just as a placeholder for now. So that would clean all that up and allow us to move forward without ever having to go back to the state legislature for our changes to personnel. And so I can stand for questions if there are any on this. I see one.
Councilmember Payne.
Thank you, Vice President Palmisano. I appreciate this clarity around what defines a vacancy. That's something I've been confused about. So my question is, with this provision here that an interim designation is not an appointment and does not fill a vacancy, does that just clarify what is true today and just make explicit, or does this change the definition of vacancy?
I'm going to have to look that up.
Page 7.
No, in my book.
Because I'm just always curious. I'm a new council member, but I've been in City Hall since the Hodges administration, and there's just been interim directors ever since I've been here.
It is one. So while Ms. Trammell's looking that up, I would offer that this is one of those changes we felt we needed to codify because, as you know, Councilmember, one of the things that the Charter Amendment did on government structure was eliminated a body that used to exist, the Executive Committee. And the Executive Committee had the authority to appoint interims. And by eliminating the Executive Committee, how do we appoint interims? And so putting this here was not to change who is an interim, but to clarify, the mayor designates an interim, the interim serves in that capacity until an appointment is made. The appointment process stays the same as it was before. The mayor nominates, the council has to consent. And then it talks about, that person serves until a successor, which would mean the appointment process coming forward. So this was really bringing forward what do we do without the executive committee, which previously had that authority to designate interims.
So then would the current language of if an office has been vacant for at least 90 days, that would include any interim position right now under the current charter?
Are we talking about 7?
An office is not vacant if there's an interim person filling. The position is vacant, there's no one serving in that capacity. So an interim person is a fill-in until a nomination comes forward, and that begins that appointment process. So an office can't sit vacant for 90 days or 30 days in the case of the police chief today.
So this would be changing that to say that an interim does not count as filling the position.
That is, if I understand your question, Councilmember, that's true today. It would continue to be true in the future. What we did here is say the mayor makes the interim designation because the executive committee, which formerly had that authority to create the interims, is gone. So it doesn't change the definition of interim or the fact that an interim is holding that office, and so it doesn't affect the vacancy piece. It's merely saying who makes the interim designation, who makes an interim appointment until a real appointment comes forward for consideration. You cannot leave any office vacant, meaning there's no head at the head of a department for that period of time that's in the charter now. And then, as you know, there's a proposal to increase the time that an office could be vacant, recognizing the need to maybe do some recruitment and posting.
Are there any other comments or questions? Not seeing any.
To add to that, in the charter, there was a vacancy which said the electing or appointing body determines when any other office, meaning other than an elected office, was vacant. Okay? So there was that vacancy determination, but there was no discussion about the appointments of the interim. So it was all done through that executive committee before. There are no other language that's been edited out related to interims. There's just the language that was in there about having the 90 or the 60 and 30 days, or 90 and 30 days to make appointments. That was changed. No other about interims.
So then an interim designation is not an appointment and does not fill a vacancy. That is as true today as it would be with this implementation.
In my opinion, yes. And someone holding over as well isn't filling a vacancy. Does that answer the question? Okay. Anybody else?
Thank you. I think we're ready for the next section.
So the next, well, actually, on the next slide, if they go to the next slide, that has to do with Articles 9. And Article 9 has some edits made to it related to addition of language and some other corrections. I don't know where my Article 9 went. Got it here. So the first clarification we made is in section 9.2 on page 1 of your document. And it is added language that says an unbudgeted payment. Apparently, we've had this issue recently. Make it clear that anything that isn't in the budget already requires that 3/4 vote. On page 2, you see some changes that are made wherever it said finance officer. Those have been changed throughout the charter whenever they're used, because the finance officer has been using the phrase chief finance officer. And so that's also what was used in the ordinance, and this is consistent with what's in the ordinance. And we clarify on page 3 that the other boards that may levy are the other taxing boards. So that clarification was added to page 3. The bigger change starts on page 4. You see it in red midway down the page. It's transferring from the other articles, the police department funding, the fire department funding, and the civil service funding. And so there, you can see that there's some strikeout in the civil service funding because there were some strikeouts from that language. But otherwise, the language itself has stayed the same. It just moved in the charter. And those are the only changes to Article 9.
Are there questions or comments about this section? I'm not seeing any.
So they're going to pull up on the screen instead of the next slide, the actual Article 10 as proposed, because it somehow didn't make its way into the printed packet.
I'm sorry, Ms. Trammell, I didn't see Member Clegg.
Sorry. Yes, that's what we were discussing just minutes ago, that it didn't seem to be here. I think we probably have 2 copies up here, maybe. But they're going to pull it up here so that you can see it. Okay, so this would be a new article. And the first, as you can see from the language, I've kept what was in the charter in the other location and edited it as if we were just editing that provision. So we've done a few things to make them consistent across the board, in that the first section is membership and the second is function and powers. And so capitalizing Civil Rights Commission, and just simplifying the language, and that the appointments, are made by ordinance for the Civil Rights Commission. Then adding kind of a policy scope sentence to the civil rights functions and powers. And then you see where that says office up there? It's reordering the phrasing and trying to use consistent phrasing throughout, so that we use the same phrase: office, department, division, board, commission, and other agency or agent, so throughout. Those are the changes, the only changes that were made to the Civil Rights Commission itself. So substantively, it stays the same. Then the Planning Commission, again, is pretty much the same. There's an edit to paragraph 6 and 7 under Part A, in that because they had some appointments appointed under Section 8.4B, which we don't have anymore in the rewrite here, we're proposed that 3 members are appointed by the council instead of 1, and then 2 members by the mayor. And so those are the changes to that Part A. Then we just clarify that we're also talking about their functions and powers in Part B, and that is pretty much the same as it was in the other section, but we're, again, making changes for consistency's purpose and capitalization. There's a new section then, if we scroll down. Keep going down. And right here. There's a new proposed commission, which is an independent ethical practices board commission. This would set that framework, which would then, have to have the amendments made to the ordinance to and adopt this. So the first section is membership, just like the other commissions. And it would increase the size of the commission from the current Ethical Practices Board from 3 to 5. And it would maintain the same service restrictions and the same appointment processes is currently in ordinance for this. And then if you move on to function and powers, it basically, and I read it since you don't have it. The commission is responsible for promoting ethical conduct, administering and enforcing the city's governmental ethics ordinances. For the purposes of enforcing the city's governmental ethics ordinances and notwithstanding anything in this charter to the contrary, the authority and jurisdiction of the commission shall extend to the mayor, the council members, the Minneapolis Park and Recreation Board commissioners, and the members of the Board of Estimate and Taxation. Currently, the jurisdiction of the Ethical Practices Board extends only to the mayor, the council members, and the BET. Employees of the city and its boards and agencies, members of the city boards and commissions, and who must cooperate with any audit or inquiry and furnish information that the commission requests. And the commission also enjoys all the powers for which any general law, special law, or ordinance provides, including any power necessary and proper for exercising its powers or performing its lawful functions. And that's the proposal to, for an independent ethical practices board. The fourth section is the Civil Service Commission. Again, the language will get you a hard copy of this sent to you. I think that Michael can send it out probably as we're talking so that you have it. And it has the strikeouts and the underline that indicate the changes from the prior charter section. And so the first is Part A, which was entitled Composition, and now it's entitled Membership. It's the former Section 8.5C2, and that stays the same for the most part in that it's still 3 members under this proposal. And but it clarifies and to make similar that they haven't in the past 5 years not been and are not currently elected officials, employees of any federal, state, municipal, or other government or collective bargaining agents or representatives. The members are appointed by the mayor with the consent of council in this version, and they serve 3-year staggered terms. The other edits from the prior, the other language stays somewhat similar, and they're always referring the former section that we had before. And there is the content of the rules and the notice of the rules. And then what's indicated as a lot of strikeout is the additional language that was in Article 8 that we don't believe is necessary for the charter. That it's, again, things that need to go in the Civil Service Commission rules. And so I can stand for questions on those changes as well.
Questions, comments, thoughts? Councilmember Wansley?
Councilmember Wamsley, if I understand the question correctly, the question is the removal of the word resident, replacing it with the word member in the, Planning Commission, is it? Civil Service. The change was made solely because the other provisions referred to members and not residents. So that is something to consider, whether we want to specify residents instead of members.
I'll jump in here and say that it's in our code of ordinances and not in charter, where it defines residency requirement and the waiver for residency on boards and commissions. So the requirement of residency is not a charter issue, it's a policy decision we've adopted by ordinance and codified. So that would be the difference.
Member DeMello?
Thank you, Vice President. Is there a reason why this proposed article is not referenced in other relevant articles, provisions addressing, like, for example, someone brought up, how do we determine malfeasance? Is relevant sections of this going into other portions of, why isn't relevant sections of this going into other articles, if that?
Chair Palmisano, Member DeMello, I think the reason why it's not is because none of these commissions are actually, like, for example, in the determination of malfeasance, none of these commissions actually have that responsibility to determine whether malfeasance from a removal perspective exists or not exists. That's something that, as we've written it, it's the council that makes that determination after a due process hearing, and we haven't given that power to, for example, the Ethical Practices Board or the Civil Service Commission or the Civil Rights Commission. So we referenced this new Article 10. If we didn't reference it elsewhere, it's because we didn't feel that these particular commissions have a role to play in the other articles, if that makes sense.
Thank you.
Thank you, Madam Chair. Just if you go back to 8.6, and I'm looking at under policy, all those items that about examination, all the things that you need to do before you get hired by in the classified service, and those are all stricken or deleted. And I think unless I missed something, did you just say that these kinds of things are something that will have to be left up to the Charter Commission in their rulemaking? Or are they someplace, did I miss, are they someplace else?
Chair Palmisano, Member Kozak, I think you're referring to my statement that the details would be included in the civil service rules.
Yeah.
And yes, that is the case. In fact, they are there now.
Oh, I see, okay.
And so we're just trying to remove some of the detail and keep it more at a high level, a usable for a constitutional document like the charter.
Okay, no, I concur, thank you.
Member Clegg?
Does the new charter level Ethics Commission have any broader or different jurisdiction than our ethics structure now under ordinance?
Chair Palmisano, Member Clegg, yes, it would. It would have the authority to enforce the ethics code. Right now, it can only make findings of fact and advise the council on action to take. And the revision, that has not proved to be very workable. And so the Ethics Board is seeking enforcement authority, and this would give them enforcement authority.
Member Garcia? I'm sorry, if you're done.
Thank you. Thank you. My question is just one a clarifying question, which is, when referring to special school district number 1 Minneapolis, is that when referring to the board rather than the public schools in general? Because in section 10, there's a reference to the public schools. So I assume that's because it's not the reference to the board itself.
Ask a clarifying question. Are you referring to the Planning Commission reference in Article 10?
I don't, it went by quickly. There it is.
Member of the school board in 5, yes.
Oh, so,
It could just be that we missed that.
okay.
Yeah, we should change that to be correct. So
Thank you.
you. Good eyes.
Thank you. Am I seeing anybody? I'm not seeing anybody else for comments. Does that mean we're through with the presentation then?
That would, yes. Thank you, Chair Palmisano.
Great. Well, thank you. Thank you for this
I think
presentation.
the last slide, though, just to wrap it up, there was one more slide that talked about sort of next steps. And in terms of next steps, our goal was to get all of the policymakers gathered, so mayor, council, charter commission together. This is a lot of information, obviously, to digest, and we certainly appreciate that you're seeing that for the first time here tonight. Our proposal has been, and we've talked about this at least with council for this term, that in order to reconcile the gaps that have been referred to between the charter amendment that passed and the ordinance that was enacted by council, putting in place a structure within the administration, that we would pursue those by ordinance. So under state law, of course, you know that there are two pathways to charter amendment. One is the ballot, one is by ordinance. The by ordinance process is much more complicated in terms of the process, but potentially easier to accommodate this much of a rewrite of the charter. And so I think our ask of this body at the appropriate time is how much of all of the proposals we've put in front of you could be accommodated by ordinance, recognizing that that path requires first the agreement by the Charter Commission that yes, these amendments to the charter could be made by ordinance. We concur with that. It requires the unanimous vote of all 13 council members and the approval of the mayor. Even then, it's subject to a petition that would require it to be submitted to voters on the ballot if a petition is filed. Or what can we pursue by ordinance and what should we not be pursuing by ordinance, so that the attorneys can sort of draft that piece together, recognizing that, of course, that'll come forward in the next term, but getting work started underway on how much of these amendments that bring alignment or closer alignment between the voter-approved government system and then the administration form that we enacted by ordinance together. So that, I think, is our ask of staff, is how extensive or how many of those pieces could be accommodated by ordinance, what can't be accommodated by ordinance, and what those next steps are from you all, the three primary actors that would be involved in any ordinance or even a ballot question to amend the city charter.
That's a good point. So are the... Oh, I'm sorry. I'm not seeing Councilmember Payne.
Yeah, I was just wondering, timeline, sequence and timeline, and at least the steps, if not like what the timing to those could be, because I know the timing would be dependent on the election and council cycle, but at least the steps that need to happen.
So to Councilmember Payne's question, the steps that would happen to proceed by ordinance in that manner would be that we'd get direction on the scope of those amendments to be included in an ordinance. This would be quite an extensive ordinance, just like the omnibus ordinance on government structure was quite extensive. My guess is that it would take many weeks for us to be consulting between the two bodies that are here and negotiating what would be included in an ordinance. At some point, of course, the normal legislative process kicks in for that. A council member has to bring forward a notice, there has to be the introduction, referral through the committee process. So I would say our goal would be to get clarity on the scope of that as soon as possible without putting a definite date on it, knowing there's an election literally in a week from today. But that, maybe before the end of this term, we could get some consensus from the body on the scope of those to go forward, so that we can start that process end of this year, into January, come back early February and say, this is the scope we hear agreement on between the two bodies, proceeding along that lines, and then anything that remains on the table would have to be addressed either by the council or by the Charter Commission. And so understanding where we find agreement between the two bodies so that the attorneys can sort of begin that process, and the attorney, Ms. Anderson, should speak to that process.
I agree with everything you said, Mr. Carr.
So I think first part of next year is we're looking for some clear direction from the two bodies about what part of that scope we've presented tonight, recognizing you need to digest a lot of information. And there was a lot of good feedback and discussion as well. So all of that has to be processed, and we'll obviously schedule more meetings in the future to hopefully secure some level of agreement between the two bodies about what could be included in an ordinance.
Mayor Fry.
I'm not sure if there's any additional commentary, but if not, I just wanted to take the time to thank everyone. Thank the Charter Commission for an extensive amount of work that they've done, especially over these last several years. The work that you've done, it matters a lot to not just our charter, but the way that we carry out our work. And thank you so much to the council members as well. We've been living in this reality, and as has been pointed out, at times sort of building the plane while flying it, and I appreciate everybody.
I know the mayor wants to go, but we have a couple other things in terms of us wrapping that up. No, you can go. For the sake of discussion, I'm going to move that we direct staff to proceed with refining and finalizing the drafts of all the recommended charter amendments as presented to be considered by Charter Commission, City Council, and Mayor by ordinance as allowed under state law. But let me be clear, my goal is not to say this is the absolute direction that we take. I think we can modify that as we go forward, but this gives us an approach as a starting point, especially since it would be the next council that would need to finalize any such vote on an ordinance. I just think this is going to help us primarily give direction to have a formal drafting process begun, and with acknowledgement and a huge appreciation for all of Ms. Trammell's work so far. Is there a second to my motion?
Second.
Seconded by Council President Jenkins. So I'll open the floor to any comments on that motion. Councilmember Ellison.
Thank you, Vice President Palmisano. It does feel to me like we, for the interest of, and I'm totally welcome any pushback, but it does feel like a ballot initiative is kind of the direction that we would end up heading in. We look through the changes here, and I think that there's things to be excited about, there's things to debate about, and, just for the sake of making sure that we're, not wasting too much time headed towards, trying to aim at a unanimous decision that I think is a stretch. I do think that, starting the conversation and being prepared to send this to voters might be, I don't know, it's something that I would advise, but I'm just one council member, and so it's more of a comment, not a motion or anything, but otherwise I'm supportive of the chair's motion.
Thank you. I agree. I think there's things to be excited about, things to debate, and things that maybe are going to need a ballot initiative, and maybe this next iteration will help give us more clarity on what those are, because I don't want to put an increasingly complex ballot initiative forward given our limits of space and questions. City Attorney Anderson.
Chair Palmisano, Council Member Ellison, members of both bodies. I would encourage you to take a look at the drafts, and there may very well be some very non-controversial things that we could just clean up through a unanimous ordinance, and that, I think there are some really meaty things in here that maybe, are best for the voters, but then there are some just really, nuts and bolts kind of stuff that If we can get those things decided and get some things in the charter cleaned up, we might be better served and have the voters concentrating on things that are more substantive.
Yeah, I think that's correct, and I'm definitely open to that, but I also want to acknowledge, I think that this is, and I feel like we had a unanimous vote to change something minor in my first term, I can't remember what it was, but that was in a system that had a lot of legacy in the city, and this system has almost none, right? We've been building it as we go, and so I just, I think that things that might appear, real nuts and bolts at first glance might elicit further debate in a way that might surprise me or in a way that might surprise others. And so, anyway, I just, want to acknowledge that the government structure has changed significantly, and so that's, and it's hard, I think it can be hard to predict on what are those things that will be considered consensus by the body, and what are those things that could generate debate. I think that line will probably end up surprising all of us, and so that's all I was acknowledging. But yes, absolutely, I think the things that we can get done unanimously, we should strive for that, so.
Councilmember Payne?
Thank you, Vice President Palmisano. Yeah, I would say things like eliminating council's role in appointing department heads is a non-starter for me. But I recognize that right now, today, this is not what we're voting on. We're voting to move the process forward, so I'm happy to vote yes today, but I also want to just be very transparent and clear that maybe I can be convinced that that's a good idea, maybe with some negotiation on some other provisions in here that I also have investment in that we can talk about later, but this would not be something that would be unanimous today if we were voting on this language today, and it would have to go to the ballot in that instance. But I recognize that today we're not voting on finalizing language, we're voting on moving this forward, so.
That's right. All right then, all in favor of the motion, could you signify by saying aye? Aye. Any opposed? That motion carries, and Chair Ginder, I'll turn the meeting over to you for any final action or comments from the Charter Commission.
Thank you, Madam Vice President. At this time, I'd invite a motion to refer this entire matter to our Standing Amendment Review Committee and ask that the co-chairs take up this matter with the goal of making a recommendation to the full commission at the end of the first quarter of next year.
So moved, Rubenstein.
Mr. Chair, I think we already have a government structure work group.
To move this matter to the Government Structure Committee.
Okay, as opposed to the Amendment
Excuse me,
Review Committee.
The Amendment Review Committee, if I misspoke, to the Amendment Review Committee.
Okay, that was my point, is we have a government structure committee. Shouldn't we be referring to that?
My belief is it would go to the Amendment Review Committee because there's more than government structure in this. They could take up the entire package. We had a second on that? We did, all right. Then all in favor, please say aye. Aye. Opposed? That matter carries, and we'll refer this package to the Amendment Review Committee for its study. And if there are no further comments from the commissioners, and without objection, I'll adjourn this portion of the joint meeting between the Charter Commission and the Council's Committee of the Whole. And I would like to express our thanks and appreciation both to the mayor and the council members for your work and collaboration on this. Thank you.
Thank you, Chair Ginder, and thank you to all of the commissioners who work on this and all of our charter issues. I'm sure I speak for my colleagues present and future when I say we're eager to work with you on furthering and developing these proposed amendments with you. With that, we've concluded all business to come before this joint meeting, and hearing no objection, I will declare this meeting adjourned. Thank you and happy Halloween.